I believe it is vital that the courts remain open. And I say that because on our delicate constitutional balance of separation of powers, the Congress has been totally ineffective on oversight and on restraining the expansion of executive authority. But the courts have the capacity, the will, and the effectiveness to maintain a balance. We find that the President has asserted his constitutional authority under Article 2 to disregard statutes, the law of the land passed by Congress and signed by the President. And I start with the Foreign Intelligence Surveillance Act, which provides that the only way to wiretap is to have a court order. And the President has initiated the terrorist surveillance program in flat violation of that statute. Now, the President argues that he has constitutional authority which supersedes the statute. And if he does, the statute cannot modify the Constitution. Only a Constitution amendment can. But that program, initiated in 2001, is still being litigated in the courts. So we don't know on the balancing test whether the President has the constitutional authority or not. But if you foreclose a judicial decision, the courts are cut off. Then the President has violated the National Security Act. Let me say the executive branch has violated the National Security Act of 1947, which mandates that the intelligence committees of both the House and Senate be informed of matters like the terrorist surveillance program. I served as chairman of the Judiciary Committee in the 109th Congress, and the chairman and the ranking member under protocol and practice ought to be notified about a program like that. But I was surprised to read about it in the newspapers one day, the final day of argument on the Patriot Act. And it was a long time with a lot of pressure really to get the confirmation of General Hayden, the CIA director, that the executive branch finally complied with the statute to notify the intelligence committees. Now, on the other hand, the courts have been effective, and I will amplify on this at a later time because I want to yield soon to Senator Whitehouse and give the opponents an opportunity to speak before 4:30. But in the Hamdan case, the Supreme Court held that the President does not have a blank check on the war on terror. The justices held that the President cannot establish military commissions unless Congress authorized it. In Hamdi, the Supreme Court concluded that due process required that a citizen held in the United States as an enemy combatant be given meaningful opportunity to contest the factual basis for that detention. And in Rasool versus Bush, the Supreme Court held that federal habeas corpus statute gave district courts jurisdiction to hear challenges by aliens held at Guantanamo Bay. Well, this is not Pakistan, where President Musharraf can suspend Supreme Court justices and hold the Chief Justice in house arrest. This is America. And the balance is maintained only because the courts are open. And I believe it would be a major, major mistake to close the courts on pending litigation when the courts have provided the only effective way to check expanded executive authority, which we have seen in many, many lines. And I'll amplify those later on items like signing statements. But that is the essence of the argument, and I'm going